forming the corporation. What do we need to know about how to form a corporation? We're going to focus on forming a Delaware corporation. So there are, of course, many different choices for that, but I'm going to focus on Delaware law. We're going to apply that in this class. And so to get there, we will preliminarily talk about choosing the state of incorporation and some of the considerations that a lawyer would make when deciding in which state to incorporate. As you know, you can incorporate in any state regardless of where you do business, and this can have ramifications for your internal affairs. The internal affairs doctrine says that a corporation will be governed by the laws of the state of incorporation regardless of where it's situated. The exception, quasi-exception, is California, who purports through Section 2115 to impose their laws on foreign corporations that have a majority business share there. But for the most part, you can make that choice of how you want to be governed, and there's many ramifications. We will then talk about the process of a Delaware incorporation, as that is the most common choice for companies that are looking to get outside funding or go public, and it's the default choice for many. That is changing as LLCs have come onto the scene. Other business entity types have changed the calculation, but Delaware is still the gold standard for corporations, so we will talk about that process in particular, both in the contents of the charter, the certificate of incorporation, and in terms of corporate formalities that have to be observed, and that's that really fun stuff of getting through all the Delaware general corporation law that we're going to do today. Then we're going to talk about the role of the lawyer, that's you one day, and the ethics that are pertaining there too. So lawyers have to represent situations before a corporation is formed. That's sort of a challenging new dynamic. You know, you have multiple people coming into your office, they may have competing interests, and you have to handle things differently when you're representing a group of individuals or an organization that has ownership interests. And then we're going to talk about one, at least discrete doctrine, and it's not something that comes up hardly ever in life, but it's something that comes up on the Pennsylvania bar. So we're going to talk about defective incorporation, in part because this doctrine is something that is tested on the Pennsylvania bar, and so it's certainly worth knowing about for that reason. It's something to avoid, and it actually does bring up some important points about agency law that will be relevant for our last module, our last chapter on binding the corporation. So let's start with our first topic of choice of the state of incorporation. And spoiler alert, in this class and on the exam, we're going to end up answering Delaware to then apply what we're learning, but let's first understand what this choice is comprised of. Generally, a corporation and its founders will have two fundamental choices to make: whether to incorporate in their home state, where they already are, or Delaware, although there are some reasons to organize in places like Wyoming and South Dakota as well. I'll talk about that in a minute. For our sake, though, corporations that you're thinking about will probably be deciding between Pennsylvania or Delaware. So what are some pro and con? What are some reasons that people incorporate in Delaware? Mary Beth.
The courts in Delaware are very well versed in corporate law and they handle it well.
Yeah, there are in fact specialty courts in Delaware that really do almost exclusively corporate law. And so if you have a corporate law issue that comes before the court, you know, it's not good. You go down to the courthouse down here, and the judge hears a criminal case on one day, you know, a divorce issue on another day, some tort, you know, or a contract claim on a third day, and then a corporate issue on a fourth day. And, you know, it's hard to be expert in all these areas, and as we've learned, corporate stuff is a little technical. So it helps that in Delaware, you get access to these specialty courts that specialize in ruling on matters of corporate law. And so lawyers like that, although business people might say, okay, whatever, I don't care, I'm not going to get sued, but we know better than that. People get sued and issues happen all the time. This has also resulted in more law. So we actually have more certainty about how Delaware courts will rule, because there's just more case law. There are more corporations in Delaware, they have more cases heard there, and as a result, we have more legal decisions. And as you learn from legal writing, it's kind of hard to come to a conclusion on how a court will rule if it hasn't been done before. You have to reason through all the policy. Much better if you can find precedent on point. And that's much easier to do in Delaware. Other reasons people like Delaware. The courts, the law, yeah.
Without being super specific, I think that Delaware leans on the side of, you know, basically board having more power over shareholders? Like,
Mhm.
I think shareholders have less rights in Delaware than maybe in California, for example.
That's certainly true relative to California. So managers might prefer Delaware because the shareholders have less rights vis-a-vis the managers than they would in some other jurisdictions, most notably California. This is a question of whether this is like a race to the top, race to the bottom. There's some theory about that, whether this really is good or bad for society. But managers seem to like Delaware. Delaware will say that it's balanced, but certainly there are states that have more shareholder-friendly regimes, like require, or certainly more protections for minority shareholders. And so managers like Delaware in part because it makes their lives a little easier to manage the company. Other reasons people like Delaware. Yeah, Michael.
No taxes. Well, lack of taxes.
So actually, there's a lot of different taxes that apply to corporations. Delaware loses from a tax perspective. Delaware is expensive. You really pay a lot to be in Delaware. So actually, what we're going to see on the next couple slides about cost, Delaware has high cost. And so that's not a reason to choose Delaware. It's a reason not to choose Delaware. So a reason not to choose Delaware is for tax reasons. There are much more tax favorable states. And if you are a foreign corporation, meaning you're not domiciled in Delaware, you would then have essentially two masters. So if you are domiciled in Pennsylvania and in Delaware, you're going to be paying Delaware taxes as well as complying with regulations registration here in Pennsylvania. Delaware adds cost. That's not a factor in its favor. That's a factor against it. Other reasons people like Delaware.
Can we just go back to the internal affairs for
Mm-hmm.
a minute? If you're telling somebody that you're planning to incorporate in Delaware, would they have to go to the Delaware Court of Chancery to resolve their disputes? Or
Yes.
Pennsylvania, so any dispute they have, they would have to go to Delaware?
So this is a jurisdictional question. It's like kind of a civil procedure type question. The Delaware courts generally hear claims on matters of Delaware law. There are some situations where a Pennsylvania court could opine on Delaware law and apply the law of Delaware while sitting in Pennsylvania. But the effort for both parties usually is to get those cases heard in Delaware. And so there are it's more of a civil procedure question as to the absolute definition. But the short answer to your question, most cases about internal affairs and governance and voting and minority rights that involve Delaware corporations would be heard by Delaware courts, even when those companies have headquarters elsewhere. Most Delaware companies are not headquartered in Delaware, not the big ones that matter. So we'll see a number of those cases as we go forward. Vantage Point, for example. That's a Delaware hearing decision, but they were residing in a different state. Yeah. Other reasons people like Delaware? Yeah. Yeah, easier. It's easier. They have a lot of you have a lot of online materials. So you can, for example, in Delaware, you can file something on an expedited basis. It may seem like a small matter, but in Pennsylvania, you can't. In California, you can't. You have to then wait until they get around to it. So you don't have as much certainty. You do have to pay more for this, but if you have an important transaction, if you're trying to file a certificate of merger, you got to get the deal done. Delaware is going to be able to rush that through in an hour. And they can also pre-approve things, which makes it easier. And they have a very good website, and we'll see something in a minute called Delaware One Stop, where you really click a button and it's all of the registration you need to do all in one place. So it really facilitates organization. I mean, this is a whole state whose business is run around doing this properly. And so you can get someone on the phone when you need to call. I mean, that's nice, like literally customer service. Now, I remember working in California at the law firm, and I'd have the phone on hold for 3 hours before someone would pick up. It's nice that you can do something else in the background. But, in Delaware, you can get a live person on the phone usually in 2 or 3 minutes. It's a huge help. It's worth a certain amount of cost because you have more certainty about that. The forms are more standardized. That's another factor. Since many people incorporate, it's sort of a virtuous cycle or a vicious cycle, depending on how you see Delaware, but because a lot of people have incorporated Delaware, there's precedent, not just in terms of law, but in terms of forms. And so if you want to form a Delaware corporation, we're going to see that's really easy. We can do that with like an online service and get documents produced very easily. You want to form a Wyoming corporation, you're going to have to do some legwork. Because those forms, they might be available in some book on Wyoming law, but they're just certainly not as plentiful or as available because Delaware has been the default for so long. Yeah.
I
Yeah, so you can actually pay a registered agent to do a lot of the work for you, and some of them are really cheap. You can have, so we'll come to this requirement in a minute, but if you are not domiciled in the state, you have to appoint someone who can receive process so that you can be sued in that state, right? So if a lawsuit in Delaware is filed, that will be served in Delaware. There needs to be someone to receive that process, and that person would be a registered agent. And a registered agent in Delaware can be as cheap as $45 a year. You can get one that offers a lot more services too, and there's like 150 of them or something. So there's a lot of competition for registered agents. I don't know how many registered agents there are in Pennsylvania offhand, but I can tell you it's a lot less. And the competition is not there. And similarly in Pennsylvania, Harrisburg is concerned about a number of different issues. They're not focused 40%, 60% of their energy on having excellent corporation law and Secretary of State services. They're focused on a number of matters. In Delaware, that's a huge part of their income, that and the darn bridge.
I can tell you a fact about the Pennsylvania Department of State.
Yes.
The Bureau of Commissions, Elections, and Legislation has only 18 employees.
Wow.
And that handles all kinds of stuff. So when you call, they sometimes have to rob people from the corporations, it's quite a order on there.
So the people working in the corporation department are subbing in at the elections office and probably vice versa in Pennsylvania. Less likely to happen in Delaware. Yeah. Yeah, so Pennsylvania, Stratford resources, right? So those are all things to think about when you incorporate. You kind of get married to the process here, and that can be a very arduous process. But that said, it's cheaper. And that's the big reason to do it. It's cheaper, and there are some reasons to incorporate in specific states for specific purposes. Like, for example, just an example, Pepsi's incorporated in North Carolina. Why North Carolina? Well, North Carolina happens to have some state statutes that make it harder to take over a company, make it easier to defend against a hostile takeover. And so Pepsi decided that, due to their structure, what have you, it's beneficial to them to have less risk of takeover. And so North Carolina did that for them. For those who know more about, credit, I know that American Express and a lot of other credit card companies, Discover, are in North Dakota. And so North Dakota obviously has some kind of favorable law for that type of business. Maybe they have higher usury. I think that might have been it. They have higher usury limits. And so they basically you can have the maximum usury available in every state. Usury is like the maximum interest you can charge. And so I don't know if that's 29.5% or 35%, but my understanding roughly is that North Dakota has a very high limit, and so then you're only subject to the limits in the state, as opposed to if North Dakota or if another state had a 19.5 limit, you can only charge that much, and so they can take more of your money if they're headquartered there. So there are special reasons for special companies, and it's something to think about, but Pennsylvania doesn't come out very far ahead on almost any measure, turns out. And so that's why even in this class, I don't really focus on Pennsylvania corporation law per se. So here's, for example, a map that shows the business taxes. So business tax is one reason to choose a state of incorporation. Something to kind of notice is that Pennsylvania is pretty middle of the pile here. Some standouts on this list: Alaska, Wyoming, South Dakota, Florida, really low on taxes. There are other reasons to choose this, but taxes are really important business proposition. Having lower taxes is important for business. It increases how much revenue your business takes home, and so ideally you're not paying too much in taxes. And this is a simple version of that, and we can, but this one here is more of an integrated chart. This chart shows states ranked on the basis of corporate tax, individual income tax, sales tax, unemployment insurance tax, and property tax. And so you can see all those in different columns. You can get a separate output for all of those. One thing to notice, by the way, is that not every company is going to need to worry about those things. A company that doesn't hold property is not going to worry about property tax. A company that doesn't have employees wouldn't worry about unemployment insurance tax. So this chart is not a perfect representation of where every company would want to incorporate. You have to do your legwork if you're making this decision, and there are a lot of factors. But I wanted to sort of just also point out that even if you take all the factors in the aggregate, Delaware starts to really come out ahead, ranks 15th overall on this particular ranking, and a lot of companies that don't have property in Delaware and don't have employees in Delaware wouldn't worry about the Delaware taxes for those matters. Pennsylvania ranks 26th. It's 44th best or 6th worst for corporate tax rates, and dead last, 50th for unemployment tax, highest unemployment tax overall in our great nation. So if you are incorporated in Pennsylvania and you want to have a business here, you're going to be paying a lot more taxes, and that's sort of an issue to deal with. Plus, as we have discussed, the Secretary of State has, I guess, their hands in a lot of cookie jars, right? And so it can be hard to get them on the phone or get anything done. But fortunately, this is just something I want you to be sort of aware of in these considerations, because we're going to go ahead and as I've pointed out, the first section of your exam is going to deal what type of entity to form, and then, spoiler alert, we're going to go ahead and form a Delaware corporation for the second set of elements. So this is really just background. There's a lot more to this consideration. We could probably spend 2 hours just on state of incorporation choices. In fact, I teach another course, Venture Capital Law, and I have a 3-hour lesson just on Delaware versus California. So you can imagine the type of analysis required for a 50-state study of this, far beyond the scope of what we need to do here. But did this give you a little bit of a perspective of the type of considerations a business person would make when making this decision? All right, so we'll start talking about the process. Delaware also has this handy-dandy flow chart. Man, is that complicated. Yes?
Well, this is like, I'm too late to ask this question because it's not directly relevant. But I saw that the venture capital law class is not being offered in the evening next semester. Is that?
That's correct. I was awarded course relief because I am teaching an additional course over Thanksgiving break and another course over the summer. And so I was awarded course relief this year. I'm sorry to say that it came out in that. Yeah, I actually was not.
Congratulations.
But thank you. Yes.
But also boo for me.
Yeah, I'm sorry. Although I hope to offer it next year if they can. But yes,
Yeah, I'm sorry.
I actually wasn't informed of this, by the way. It was sort of surprising.
Congrats.
But yes, thank you. Someone messaged me and said, "Hey, I tried to sign up for your course. Looks like it was canceled." So I guess that's what happened. I didn't get any official notification, but I was scheduled to teach 13 credit hours. My contract is for 12, and then I picked up the 15 credit hour course in France, which is a credit hour, and another 15 hour credit hour course in Poland, totaling 15 credit hours. And so I had requested the relief, hadn't heard back, looks like it was granted. So that's awesome for me.
Congrats.
Yeah.
On all of that.
Thank you. It's nice to know the administration is listening sometimes, but I found out kind of through the grapevine in a kind of but that's the answer to your question. Look forward to it the following year. Okay, handy dandy chart, Delaware, handy dandy chart. So this is, they do provide some things that, incorporation is a simple process in some ways, but there really are a lot of steps. None of it is rocket science. And fortunately, with Delaware, they put it all online, and you can kind of step through it based on, if you're forming this, that, the other thing. It actually turns out to be a helpful flow chart, but the key thing to notice here is that there are a lot of steps. We're not going to deal with all of those steps. We're going to deal with some of the real fundamentals about filing the certificate and what that has to involve. But a business is going to have to deal with a lot of different things. It has to form, it has to register with the IRS, it has to register with a local jurisdiction. If it's a foreign corporation, being a Delaware corporation, it has to register in Pennsylvania. It has to register, if it has employees, with the Department of Labor, with the Department of Finance, Division of Revenue, potentially with many, many other agencies. Delaware does have, makes it a little easier. If you're doing Delaware, you choose your entity type, and then there's a set of forms that come along with that entity type. And then you register that with the Delaware Secretary of State. And once that form is registered, you now have an existing company. And the next step is to get an employee identification number from the IRS. And now you are recognized as an existing entity under the federal system as well. If you are, as we're kind of hypothetically thinking, we're existing in Pennsylvania, but we're going to incorporate in Delaware, so we have to register with Pennsylvania Secretary of State. There's a form for that. You go on, and there's a link in here for those of you who are interested. I'm certainly happy to share the links, but this is stuff that's all very Googleable. You Google, you have to know what you're looking for, but it's all just publicly available on websites. So you Google Pennsylvania Secretary of State Foreign Corporation Registration Form, for example, or foreign limited liability company registration form. And it's all out there and reasonably well organized. Delaware, as I mentioned, makes it easier. They have a process called One Stop, and the One Stop system, called the One Stop Business Registration and Licensing System, is one website where you can get all your licensing from all the different Delaware agencies on one website. As opposed to in Pennsylvania, you have to visit each agency separately. They each have their own forms. They each have their own password requirements. So forget about trying to remember one password that works for everywhere. One doesn't allow you to use exclamation marks. The other requires you to have an exclamation, a lowercase, an uppercase, and a number. So anyway, I digress. If you have to do it, you have to do it, right? But ideally, it would be nice if states adopted some of these more modern systems. So what does it cost to get all of this? Well, these numbers vary, but basically, just to give you a general perspective of what to expect to spend in fees. The first cost is the cost of actually filing the Certificate of Incorporation, which, by the way, is also referred to as a charter. This gets a little confusing. It's kind of semantics. Charter can sometimes refer to the certificate and the bylaws, but it always contains, at least within it, the concept of the Certificate of Incorporation. And by the way, that'll make more sense next week when we see one and we see a bylaws. We're going to generate those documents, and then hopefully that will give something tangible that you can literally take home with you or put on your web. You can get it from Box, and you can have access to these files and actually see what these documents are. But filing, it's a little under $100. As we mentioned, you need to get a registered agent. Kind of ranges in price depending on how many services they provide, anywhere from $50 to about $350. And that's so that they can accept process, so that you can be sued in Delaware. And so that's a requirement. Delaware, though, has taxes, and the minimum that it's possible to pay a year is $175 a year in taxes, but they go up really quickly, and if you're not careful, you can end up owing a huge amount of tax if you've structured improperly. So I will talk next week a little bit about structuring to minimize your Delaware franchise tax, but this is a tax that you pay to Delaware simply for existing, and depending on how you structure it, the additional amount above the $175 minimum can go up really quickly depending on your revenues and how many shares you have authorized. But we'll do the calculation next week in the workshop, whereas here, just know that you have to pay at least $175. That's my approach. The way to do that is you have only 5,000 shares authorized. If you need more than 5,000 shares, you have to take a different approach where the minimum is $350. And again, those numbers go up once you start generating some money. But we'll talk about that more next week. And then you would have to pay, in addition, foreign fees, meaning fees for Pennsylvania. There it is, foreign fees. Right, so that depends on what state you have to register in. And you may have to register, if you're doing business in many states, you have to register potentially in all of them, maybe with different agencies within those states. So it can get expensive. But that's what you're looking at. It's actually not that much a year. But as I mentioned, if you don't plan the franchise tax properly, you can find yourself with a huge bill. One of the ways, as I mentioned, how that happens is if you have a lot of shares authorized, they can actually basically send you. I've had clients who've gotten startup clients, like brand new companies that have gotten a bill that was like $212,000. Now, we fixed it, right? And we changed the method that they used to calculate that, and we adjusted that. But it's very scary when your clients get a bill for $212,000. They tend to be very upset and a little anxious. It's good if you're able to get that call and you understand where that came from. We'll see that next week when we do the calculator. Any questions then, just kind of about basics there? Yes?
What's the annual report thing?
In addition, so when you pay your franchise taxes, you also file an annual report. And I have a slide coming up in a few minutes that talks about what that report contains. The reason that I wanted to mention the annual report a couple of times is that it is a filing requirement. As it's stated, it is done annually after the first anniversary and thereafter, and it contains information that is not required to be in the Certificate of Incorporation. So it's important to know that, because your clients may think they're going to keep certain information confidential, but they actually have to disclose it on the annual report. So they get a year before they have to disclose it. But don't be fooled by the requirements of the certificate, the charter, of the low level of disclosure, because more will be disclosed at the annual report. And by the way, for clients that are trying to be secretive or trying to obfuscate that for one reason or another, it's a reason that an LLC might be preferable. LLCs have fewer disclosure requirements on a regular basis. So just kind of thinking back to organizational choices. But I have a couple slides on that as we get into the law, and I already get my citations out here. We're going to start with the 100s, and we'll get to the 500s by the end of today. Okay? It's a good question. Other questions? Who forms a corporation? What do we call a person who forms a corporation? Yes? The incorporator. That was an easy one. You should be able to get that one on the, right? You had to guess, right? The incorporator. And the incorporator is one or more persons. So you could have multiple incorporators. And what do they do? How do they complete the incorporation process? Yes?
File paperwork with the Secretary of State.
And yes, paperwork. What exactly do they file?
Articles of incorporation.
So I'm glad you said articles, because that's half right. It's the same concept, but in Delaware uses different names for different things. Delaware calls it a certificate of incorporation. Your book is referring to the Model Business Corporations Act, and the Model Business Corporations Act calls it the Articles of Incorporation. But what jurisdiction are we dealing with? Delaware. And so we're going to use Delaware's terminology, and Delaware calls that the Certificate of Incorporation. So go ahead and refer to it as a Certificate of Incorporation. That's what we'll be filing in Delaware. And that certificate has information, which we'll go over, including the corporation's name, its authorized shares, the incorporator, and its purpose. Oh, I'm a slide behind. Oh. What's that? Okay, anyway. Process of view. Okay, so the keynote works a little differently in PowerPoint here. That's okay. So what words must be included in a corporation's name? Yes? Corporation Corp. There are other choices. Corporation Corp, Inc., Club, Company. There are a number of words. They're all listed in Delaware General Corporation Law, Section 102. And that list includes Inc., Incorporated. Basically, abbreviations of all of these words are included as well. Association, company, which would be co, club, foundation, fund, incorporated, or Inc., institute, society, union, syndicate, or limited. And if you need to look that up, it's right there. By the way, you can Google just DGCL. It will get you right to the Delaware General Corporation Law. It's in Section 1, name. So all of this is information you get online. There are also some words it cannot contain. What are words that cannot be contained in a corporation's name unless it has sort of special dispensation? You can't call it a bank if it's not a bank. And you can't call it a trust if it's not a trust. And so there are special rules about what is a bank. Banks have to register as banks. If you're not a bank, you can't call it a bank. There was also some cases where companies, like online learning companies, tried to call themselves university, and there was some dispute over whether that name was appropriate. So go ahead and put university into your list of names not to use, because that's gotten some people into some issues before. So basically, avoid those words, use these magic words. They are required. Why are they required? Why do we require names like Inc. and Incorporated? What do you think, Joe? Why would we require a company to have those magic words on its name? What does that do?
Signifies what kind of company they are.
Yeah, it signifies, and it signifies, it does, right, the reason we have these names, it signifies to the world that this is a limited liability entity. It says to the world that if you do business with this company, you can't sue its shareholders. And those magic words are important because, as we'll see, limited liability is a double-edged sword. There are some societal consequences for having it. So we're going to require some really clear disclosure of that, and something like Incorporated puts the world on notice that the shareholders are not going to be liable if that company doesn't pay its bills. Okay. Who are incorporators? We talked about that, section 101A. So an incorporator, I'll also mention this, can be another company. An incorporator can be any person, partnership, association, or corporation. Now this is distinguishable from a requirement for directors. What's the requirement for directors? Can directors be corporations? Directors cannot be corporations. Directors can only be natural people, human beings. Whereas an incorporator could be another corporation. So that means that before that corporation does anything, that incorporator needs to go, right, and be replaced by the directors. And so the other lesson from this is that the incorporator can only incorporate the company. They cannot authorize any further changes. So the incorporator steps aside as soon as the incorporation is complete, and a natural person has to take the helm. And only a natural person can be a director of a corporation in Delaware. And the way you file under pursuant section 101A, again, right at the beginning of the statute, you file the certificate of incorporation with the Division of Corporations in the Department of State. All right, corporate purpose. For what purposes can you organize a corporation? Yes? Any lawful purpose. Any lawful purpose. So you can't run a corporation called Hitman Co. Turns out that it's illegal to put a hit out on somebody, and so you can't create Hitman Co. and organize a corporation for the purpose of assassinating your neighbors. Okay? But any lawful purpose will do, and as a result, most corporations will form with this any lawful purpose language. Next week I will show you a model form for a Delaware Certificate of Incorporation, and it doesn't even have a blank space for purpose. It just says any purpose, any lawful purpose in the form, because basically nobody is going to limit their purpose at that stage. There's no reason to limit it. It doesn't do you any good. The only time you'd want to limit a corporate purpose is if you have a nonprofit. We don't focus on nonprofits here, but a nonprofit has to have proscribed, circumscribed action so that it maintains its nonprofit status. And so in that case, you want to have that limitation, but most corporations incorporate for any lawful purpose. You also have to disclose the number of authorized shares. We talked a little bit of authorized, outstanding, right? We're going to come back to that in our very last lesson on capital structure. Why are the number of authorized shares a required element of the certificate of incorporation? What does that matter? What can you learn from the number of authorized shares? Why would someone want to know that? Who would want to know that? Yeah. Investor, right? Because that tells them the total amount of pie that's out there, so they know how big their slice is. An investor needs to know this information. There's also some information on there that investors don't need to know called par value. I'll get back to that in a minute. But the idea of knowing how big the pie could be, that's really important, because otherwise you don't know if 1,000 shares is a big slice or a small slice. And at the end of the day, it's all about percentages, not about aggregate numbers. So if there's 1,000 authorized shares and you buy 100 of them, you have a big old piece of pie, right? A tenth. There's 10 million authorized shares, you don't have much at all. You barely have a crumb, right? So the authorized shares is really important for investors. And so it's required. How about a registered agent? We briefly touched on this. I mentioned a registered agent is another aspect that is required. Why do we require that? Who would want to know the registered agent? Yes?
Someone who's going to sue you?
Yeah, so you know how to sue them, right? In order to sue a Delaware corporation, you have to serve process in Delaware. And in order to serve process in Delaware, someone has to receive service of process. That person's a registered agent, has to be listed because it has to be readily identifiable. Go on the internet and find out how to sue this company. Delaware requires that. Part of the privilege of being able to incorporate there is the fact that you get to be sued there. Question, Mike?
Do you just go to the Department of State to find the address to non-service to?
Yes, yes, I can show you that actually. There, let's.
I was wondering if you had to sue Kmart, or something like that. 'Cause I had to do that, but I wasn't sure how to get that.
So I don't know if that's I don't know if Kmart is in Delaware, but if we go to the Delaware corporate name search, get a business entity search, first link there. Maybe Walmart. I think Walmart was. All right, there's a lot of Walmart. I don't know. So apparently they have a property company. It should have come up. Been here telling you how great their website is, and should be able to click on this and get all the relevant information. Why does it keep bouncing back? You see, it keeps looping to the front site here. I'll try another one.
Maybe it's supposed to open a new page on the internet.
Oh, I see. There's like a JavaScript thing here. Yeah, let me. I think there's some issue with this browser and JavaScript. Well, take my word for it. That's how you find it. It's really pretty easy. A couple steps. Hopefully, you don't have a lockdown Podium browser when you're trying to look at it, and you can enable pop-ups. But I think that's right. I don't remember if you need to pay $10 to run a search to get that information, but I think it's free. I think it's just you click through, and so anyone, by the way, wants to try it from their desks here, you can just did you get it? It worked?
Yeah, it is, Walmart Inc. is there.
And you were able to click through and get the information. So how do we sue Walmart?
Let's see where the registered agent information is. Oh gosh, there's a lot of
We'll look at it all. We're going to go through
Yeah,
that.
it's got the whole report.
Yeah, so you've got a ton of information out there. So you can check that out and see what information is freely available. And then for, I think, $10, you can find out if they're up to date on their franchise taxes and things like that as well. I think there's a full form of all their history. For $20, you get a whole list of every name change they've had, every merger they've had as well. Yeah.
Corporation Trust Company.
Great, Corporation Trust Company. So that's a registered agent. And if you want to sue Walmart, you go to the Corporation Trust Company and you serve process there. So thank you for that. I don't know why the Podium computer didn't get around to it, but apparently it's a pop. JavaScript, they're advanced, more advanced than our Podiums here. So that's why we have the registered agent, easy to find, and that way you need to sue someone in Delaware, it's 3 mouse clicks in a search box. The certificate of incorporation must also have some information about some people that are behind the company. So which of these things is true? The certificate of incorporation must include come on, there we go. Which of these must it include? Does the certificate of incorporation have to name the incorporator? Yes.
I think it does.
It does. The incorporator is required. Are the shareholders, do they have to be named? Do you have to name the shareholders? No. How about the directors? Are they named? Only if there's an immediate switch of the incorporator to the directors, so they're automatically appointed. But you can get away from that by having a separate document called an action by incorporator, which I will show you next week, and it's considered a best practice. So directors, that's a maybe. Directors are if the incorporator is automatically replaced by a director, then you do have to name that director. But if you go through this one additional step of having an action by incorporator, you don't need to list the directors. And that is a best practice. So you can go ahead and say, yes, you don't have to list the directors, but you have to file you don't actually file it, but you would have an action of incorporator. And I will show you that document next week. We will build that document. And finally, the officers. The officers have to be mentioned on this form. CEO, CFO. Yes or no?
Oh, no.
Not required. Not required. So the only thing that has to be on here has to be, the incorporator has to be on the certificate of incorporation, and we can avoid the directors as well. So I point this out because I will show you a slide where I break down the difference between what's on the annual report and what is on the certificate of incorporation. Some of that additional information is required on the annual report. Okay, how many directors does a corporation have to have? Does it have to have any? The answer is 1. The minimum is 1. Every corporation must have at least 1 director. DGCL, by the way, that's short for Delaware General Corporation Law, because that's kind of a tongue twister. DGCL section 141B says the board of directors of a corporation shall consist of 1 or more members, each of whom shall be a natural person. Do these directors have to be stockholders? Do the directors of a corporation have to be stockholders of that corporation?
They can't be typically, or like it has to be in the, whether they can or can't be is in the articles of incorporation, right? Or am I like confused?
Well, I think you're confused. Yeah, so, yeah. The Articles of Incorporation will go back to what they require. It does
I'm
not.
sorry, I read the question wrong.
Ah,
Yeah,
do the directors
Yeah.
can they be directors even if they're not stockholders?
yeah.
Yes, they can.
And
Yes,
that's
they
for
can.
like a closed director or something, right? Isn't there a term for that, or am I just?
There are 2 types of directors. There are inside directors and outside directors. And so the reason that we have that distinction is because not all the directors have to be stockholders. Directors that happen to be stockholders are inside directors. Directors that are not stockholders are outside directors. And the fact that there are outside directors, there's your answer to the question. The directors do not need to be stockholders. Now, I think to your point, the certificate of incorporation can require this. It is an optional requirement, but it is not mandatory, and it's very uncommon. Maybe in a closed company, but it's sort of a why kind of thing. It's uncommon. But the general rules, it's not required, but the certificate of incorporation has a lot of optional provisions. I'm not going to go through all of them. You can check them out in section 102. It's about 3 printed pages worth of content on that, and one of those aspects is you can limit who can be a director. So let's take a look at a certificate of incorporation. Is this valid? Does this contain all the information required by the DGCL for a valid certificate of incorporation? Who thinks that this is sufficient? That contains all the required elements under 102? And who thinks they see something missing? No one's going to volunteer on that one, huh? What's missing? Is there anything missing? This is a complete document. This is a complete document. There is not anything missing here. We have the name of the corporation. We need the name of the corporation. We have the address of the corporation's registered office. We have the total number of shares and the par value of those shares, or no par value. I'll talk about par value on the next slide. We have the nature of the business, any lawful purpose, that's the common one. And we have the name and mailing address of the incorporator, which again could be a corporation, right? So there's a way to sort of obfuscate the address of any natural persons on here. And it's signed and filed. So this is as bare bones as you can get with complying with 102. There are some formal requirements in terms of kind of the look and feel that Delaware will accept, but this meets the letter of the law. Again, those 5 elements that need to be present are here. Name of corporation. Address of the corporation's registered office, meaning the name and address of its registered agent. That isn't necessarily the corporate headquarters. That's where you can serve process. It has to be on there because you have to be able to sue the corporation. You need to have the total number of authorized shares and either their par value or that there is no par value. We will talk about par value. We have to have the name and mailing address of the incorporator, but keep in mind that could be a corporation, so it's not necessarily a person's home address, but it could be. And we need to have the purpose, the business purpose. And usually, if not always, it is any lawful purpose. That meets the bare bones requirements of a charter, of a certificate of incorporation under 102. So what is this par value business? So par value is kind of a anachronistic concept. So historically, corporations had the concept of par value to protect investors. because a corporation is not allowed to sell its stock for less than its par value. And so you would know that if you were getting, that no one was getting a better deal than that. Now that has become completely unnecessary with public markets, where you know at a fraction of a millisecond what everyone is paying for every stock, every share of stock. And in private markets, when you have sophisticated investors, they generally will ask for this information, and they should receive it. They can ask for, they should ask for, and they will receive, or they shouldn't invest, the price that everyone else has paid. And they can have contractual provisions that limit how low you can sell future rounds of stock for. It's a more complicated nuance of preferred stock provisions. So why do we have this still? Well, it's sort of an archaic holdover, but it does have this function. You may be, by the way, more familiar with par value with referred to bonds. Some of you who do more finance work. Par value is the face value of a bond, the original issue value of a bond. So if you go and if a bond is a debt instrument, so a corporation can issue a bond, it's basically asking for a loan from the public markets. And so a corporation can do this, and they could sell the bond for, say, $1,000. So they receive that $1,000, and then they pay you a coupon for a period of time, and then they redeem that amount. So if it's a $1,000 bond with a 10% coupon over a 10-year period, that means that you pay the corporation $1,000 today. It's $1,000 face value. And then every year they pay you 10%, that's $100. And at the end, and literally, my grandpa used to have these. They literally used to be coupons on them, like that you'd like clip, you know, like the dog walk ad kind of things. I mean, little dangly pieces that you'd cut off and you'd send in, and they'd send you money. So you'd clip the $1,000 bond, 10% coupon. You know that it's going to be $100 every time you send it in. You clip the coupon, you send it in, you get your $100. At the end, you send the certificate back in. They give you the $1,000 back. So in this very simple hypothetical, this particular bond would have returned $2,000 over 10 years with an initial investment of $1,000. And so you would make 100%. Right? So that's a nice investment. But you can also, if you have this bond, right, let's say you've clipped a coupon, and you now want the money now. You don't want to wait a year to clip another coupon. You could sell that bond to another person. Okay? You can take that bond, sell it to another person. And how much they'll value it? Well, that depends. Depends on how the corporation has done since then. If the corporation has done better, maybe they'll even pay more for it. If the corporation has done better and interest rates have gone down, I mean, nowadays 10% sounds awesome. If you could get a 10% return from Google, you would pay potentially more than $1,000 for that, because you can't do better than that right now. On the other hand, markets could go the other way. So the value that a person will pay for a bond can change, but its original value is fixed. It's written right on the instrument, and that's why it's called its face value. It's how much it was originally paid for, and that is also called the par value. So that concept's a little more straightforward. Similarly, though, with stock, the idea with par value is the lowest amount stock can be sold at. The practical import of all this is basically you set your par value to an infinitesimally small number. And that way you never run the risk of selling the stock for less than the par value. Now you don't even have to set it to a penny. A penny is probably too much for some of these. Depends on how many shares you have. But if you're issuing 10 million shares, which is sort of common for a startup company that is trying to attract investors and trying to hire a large number of employees and give them stock options, you would set that par value to 0.0001 or something really small like that. So it becomes a meaningless number, and of course you're not going to sell it for less than that, and it's just sort of an archaic holdover. As a result, more modern systems allow you to have shares without par value. But that's at least the concept, and you will see it fairly often in Delaware charters. Does that make sense? Yes?
Wasn't community office space, like, didn't that deal with the, like, 0.00001 cent of things?
I mostly remember destroying the fax machine outside from that movie. That's been a little while. I don't know. I don't remember also. Send me a clip and we can bring it up next week. All right. So this all has to do with sort of some information about the capital structure. The capital structure meaning how the shares are organized. So the other aspect that's going to be in a charter, not required, because a corporation can have a very simple capital structure. The minimum capital structure would be 1 share of common stock. That's sufficient. You can have a corporation that has 1 share of common stock, and that's pretty simple. But you can also have a lot more complicated structures. You could have preferred stock, which have different rights and so on and so forth. And so when you get into deals like that, that's when venture attorneys develop much more robust and complicated certificates of incorporation. But every share of stock, every class of stock, every series of stock, the fundamental rights for it need to be in the charter. And so if you have a more complicated venture-backed company that's issued preferred stock, that's going to be in the charter as well. It's not a requirement because you don't have to do that, but if you're going to issue preferred stock, you have to authorize it in the charter, and you have to specify the rights there. So what does capital structure include? Just a quick review, a quick recap. Capital structure means debts the company has issued, just like the bonds that I had talked about. Capital structure includes common stock, which is going to get the residual from the company, and preferred stock, which is specific to venture capital investing and other types of private equity investing, which have a lot of additional, what we call bells and whistles, additional rights. What are some of those rights? Just for your edification, what kind of rights come with preferred stock? They may have additional voting rights. For example, the Series A shareholders might have the right to block an issuance of Series B stock, so they might get additional voting rights. If the company sells in a merger or if it liquidates because of bankruptcy, they usually get paid first, and they may get paid a multiple of what they invested. It's called the liquidation multiple. They may get dividends. Dividends are kind of like that coupon for a bond, where if it's a mandatory dividend, they get a certain amount of money on a regular basis, or they might get rights to special dividends. They get paid special dividends first. And they might, in the charter, specify that the preferred get a board seat and some control rights, in addition to those voting rights, that they get to always pick at least one member of the board. And so that can be very valuable as well. So again, what you need to know for this class, not venture capital class, is that there are 2 essentially flavors of stock: common stock, which gets the ordinary rights, and you have a simple charter; preferred stock, which has additional rights such as these. These rights would need to be included in the charter. Preferences. It's called preferred stock because they get preferences. How many shareholders does a corporation need to have? Can they have 0? Can you have a corporation with no shareholders? Is it 0 or is it 1? That's really the question. It's not 2. I'll give you a hint. It's not 2. Is it 0 or is it 1? It's 1. 1. You can't have a corporation, can't have a non-stock for-profit corporation. You have to have some owners at the end of the day. You can't have a non-profit, non-stock corporation. We're not going to deal with those in this class, so you need to have 1 shareholder at least. But again, 1 shareholder and 1 share of stock and 1 director, they can all be the same person, is fine. That meets the minimum requirement. How do you change the authorized number of shares? How do you change the authorized number of shares? Anybody know? Where is the authorized number of shares listed? Yeah. On the certificate. So in order to change that number, you have to amend the certificate. And so, very simply, to change the number of authorized shares, you have to file an amended certificate. You have to file an amended certificate with the Secretary of State. And that's how you would change the number of shares you authorize. All right, so we're going to talk a little more next week once we see the documents, and then substantially more in the coming weeks about how we animate the corporation once it's been incorporated, what happens after incorporation. So this is just kind of your sneak preview, right? So you don't have to worry about catching all of this. But after the corporation is formed, there has to be an organizational meeting. And at that meeting, a number of things are handled. It's going to make a lot more sense when you physically have a copy of the organizational minutes in your hands. So you will get that. By the end of class, by this time next Wednesday, you will have a document that says organizational resolutions and has all these resolutions in it. So this will become more tangible. But just so you have an idea, the type of things a corporation has to do after it's formed, it has to ratify the directors or appoint the directors. It has to appoint officers who are going to act for the company. It has to adopt bylaws. it has to choose a bank, so a corporation needs to have a separate bank account, authorizing that bank account, authorizing the issuance of shares and the price of those shares, any other agreements. There are a number of other things that come up, and we will see all of those on a document, and that's the post-incorporation matters. Another aspect that we would think about and we will see is the action by incorporator. As I mentioned, the incorporator has a role to play that ends as soon as the incorporation is complete. If you don't want to disclose the directors on the certificate of incorporation, then you need to have a separate action by incorporator where after the corporation is formed, then the incorporator sort of hands the corporation over to directors, and that avoids the need to list the directors. I will show you that document next week as well as the organizational resolutions. And then the other document, which we're going to come back to today, is that annual report, which needs to be filed and also contains some information. So what is on that? This is a quick summary then of what is required on the certificate and the annual report. So as you can see, the annual report is going to add certain features, most notably the name and address of all the directors and the officer signing the report. That is a key addition. So now the names and addresses of the directors get disclosed on the annual report, as well as the corporate officer who signed the charter, who signed the report. It's usually going to be the secretary, it could be the CEO, doesn't matter really. One of the main, could be the president, but now that information is going to actually come out. So just in case your clients thought that they could remain secret forever, remember that directors are natural persons and they have home addresses, and those get filed with Delaware. And so if you don't want that to happen, there are other forms in other states that have fewer disclosure requirements, but this is a requirement for a Delaware corporation. Not at the instance, but after a year. And that surprises some people because they go through the process and they think that this isn't going to be disclosed, and then they get the annual report a year later and realize that they're now obligated to reveal their home address. Some people really don't want to do that, right, for a number of reasons, so something to keep in mind. So before I jump into the next topic, a sort of role of lawyers and ethics, any kind of questions about some of those basic formalities? You should come away with this knowing a few basic things. One, you should know the 5 things that are required in a Delaware charter. You should know that that charter has to be filed with the Secretary of State. You should know that it has to be amended if you're going to change the number of authorized shares. You should know that every year you also must file an annual report which has more disclosures, including the names and addresses of the directors and the officer signing the document. And so after that, you should be able to look at a corporate charter, a proposed charter, and determine whether or not it meets those basic elements. And like I mentioned, we will see one next week. There are also many optional elements. The one we build is going to have several of those optional elements. So I'd like you to kind of be able to determine which of these elements are essential, required, mandatory, which are optional, additional, extra. Yes? These slides? Yeah, I'm happy to post them. But by the way, as I mentioned, if you just pull up Delaware General Corporation Law, I mean, it's all there. It's all there. And it's in, I think this material is in the casebook too. So you have it in a lot of different ways. I will gladly post these slides, but take a look at that. If you have any confusion on it, there's not a lot of reading load for the rest of this course. Take a look at that statute. Just a couple pages, section 101, section 102, right at the beginning, and it's also in the casebook, and it will be on the slides. A couple things to keep in mind. So what's not in those rules is this concept of sort of the role of lawyers, which really comes from the model rules of ethics. So the first question that we have to ask when we have an opportunity to incorporate a company is, who is the client? If you're representing a startup company that hasn't been formed yet, what does that mean? Who do you represent? Do you know, John?
When you represent the company, the issue becomes what's your relationship with the individuals who are forming the company prior, and how does that carry over?
But the company doesn't exist yet. Until the certificate is filed, the company does not exist, right? The company comes into existence when the Delaware Secretary literally stamps the certificate. That brings the company into existence. So, how do you represent something that doesn't exist? This is metaphysics, right? You thought this was corporations class. It's metaphysics class. Well, the lawyer at this point is said to be the representative of the situation, which is a slightly different concept. That corporation doesn't exist yet, and so at this point, in the pre-incorporation stages, the lawyer represents the situation. Yeah, it's challenging. And what does that mean if there are multiple parties of interest here? So we're going to go through a series of hypotheticals to help flesh this out a little bit. I think that'll be the best way to understand this, through a series of hypotheticals here. Because, as John pointed out, you've got people in the room, but you actually don't represent them. And you have to let them know that. So if you represent the situation, who do you not represent? Tom, Dick, and Harry, right? I mean, you don't represent the people. So there is a distinction there. And you will come to represent that corporation, and that corporation may have interests at odds with the person who hired you. I mean, look at Uber. Travis Kalanick came to a startup company, a firm that I work for, Fenwick and West, with the idea of Uber. He paid the bills, he had the meetings. Eventually, Travis wasn't so good for Uber. Who does Fenwick represent? Uber, not Travis. Now that's hard because you've been talking to Travis for 7 years, and he writes 7-figure checks with your firm's name on it. So, you piss him off, he's probably going to go to another firm, end up not being with the company. There's some real challenges, some real ethical challenges built into this idea of representing the company, because you don't talk to a company, you talk to human beings who come before you, but you don't represent them. And this creates some tensions and some confusion within the client. And I think the Travis Kalanick story is a good one because, eventually it became clear that he wasn't good for that company anymore. So who do you represent? You represent the company. He's going to have to get his own lawyer. You can't represent him. You're conflicted out of that. So I guess a fundamental question is, do people who are acting as a corporation or who are trying to form a corporation, do they know this? Yes?
Does the attorney only get paid then post-incorporation?
That depends how you structure it. Yeah, I mean, I prefer an arrangement, because they're really straightforward once you know what you're doing. So you can have a pretty good estimate on how much time it will take you. So it's nice to be able to just bill up front and then go ahead and perform the services. It avoids collections and it avoids any messy issues like this. But if it's a more nuanced situation, or they think that they can do it quicker or what have you, they may want to negotiate for an hourly arrangement, in which case, yeah, you're going to have to do the work and send them a bill. But there's nothing wrong with doing it as a fixed fee basis and charging in advance, but it has to do with market conditions. Is your client going to accept that? So do people acting as a corporation know this? Professional ethics rules require the lawyer to communicate this. Model Rule 1.7 says that a lawyer acting in a capacity such as this has to communicate to the parties the advantages and risks of this type of multiple representation. There are other situations where there could be multiple representation as well. Like, for example, a man and woman can come to an office and to try to arbitrate a divorce type proceeding before it goes anywhere. And there can be some challenges in family law with the ability to do that as well. So this is not the only situation in law where you might have multiple representation, and they're always hairy. And the rule is Model Rule 1.7. And whether or not you can do this has to do with some theory. It has to do with whether or not a particular jurisdiction is going to take the aggregate theory of the corporation. What is the difference between the aggregate theory and the entity theory in regards to the situation? What would it mean to have the situation be an aggregate? An aggregate of what? Yeah. Yeah, exactly. An aggregate of people you're dealing with. And if the situation is an entity, one step removed. So if this is an aggregate theory of representation, the lawyer represents both the participants and the corporation. If there is an entity theory, it only is the corporation that's being represented. This is a real fine point of ethical rules, and it tends to be something that gets litigated. So it's something to just be careful about. There's not like a clear answer on this, and different judges, different courts could hold differently, depending on how they see the situation and what the intentions of the parties were. All right, I think a hypothetical is going to help make this more clear, and we'll spend most of the rest of the class running through hypotheticals. Take a look at this one, and then who do you represent? So we know a corporation is a legal person, but it's not a natural person, and it's comprised of various people, and it doesn't exist yet. So at this point, who do you represent? Or what do you represent?
Well, you represent the situation because you're forming the corporation. Then in the aggregate theory, you represent the corporation as well as at this stage, Basil, Gowan, and Sybil.
Right.
As
So this is a messy situation at this point. Now, one strategy through this is to try to make it clear in your engagement letter that you do not represent Sybil and Gowan and Basil. But you just represented Basil before, so there is an issue of a conflict of interest here. If you don't represent Basil and the interest of the situation is adverse to him and he's your former client, you might run into some issues. So the best approach at this stage is informed consent. So a lawyer at this stage needs to advise the client, the people, advise the people, each of them, that he acts for the situation and will represent the corporation. That's trying to put us in the bucket of entity theory, and I hope we can see that as attorneys, we'd prefer the entity theory, not the aggregate theory, because we don't want to have a messy, complicated representation. It's nicer to have it clean and fixed in the corporation to be, the situation that will become a corporation. And so the lawyer will specify in the engagement letter that he acts for the situation and that no one client is represented. They only are represented to the extent they are part of that situation. But there can be issues that come up if you learn something from that former representation. So let's turn the hypothetical one dimension. You represented Basil in a previous divorce, as mentioned before. Gives you some information. What here? What should you do? What has Basil just told you?
He's broke and wants to take as much money out of the corporation as he can.
Yeah, he wants to, effectively he's telling you he wants to steal from this new client that you have, this corporation that you're going to form. He wants to really extract money from that situation. Does this present a conflict of interest? Sure. Sure. You represent a situation, and that situation is now at odds with a former client. So, you will need to, at this point, consult the model rules. Hopefully you're in a firm and there's a general counsel who deals with this sort of thing, but this is precisely the type of issue that comes up, because do you still represent Basil? Do you still have obligations to Basil after you've concluded his divorce?
So
Yeah.
does Basil still have an attorney-client privilege for this, if this would be?
Yes. Yes. So Model Rule 1.6 specifically says that. That's exactly right. Right? Confidentiality of information. A lawyer shall not reveal information relating to the representative of a client unless the client gives informed consent. This seems like this child support alimony. Does that relate to a divorce? You represented Basil in a divorce. He's talking about child support and alimony. Does this seem related? Child support and alimony are related to divorce. Did he give you information? Yes, he did. You now have information which is related to a representation. You have an obligation to keep that confidential. However, this information is telling you that your other client, the situation, is at risk. How can you balance that? Can you still represent the corporation? At this point, you may have to withdraw. At this point, even at this point, you may not be able to represent the corporation. How would you manage to do it? What would you have to do? If you really want to represent the corporation, what would you have to do?
I think you would have to get, affirmative consent from Basil.
That's exactly right.
To say, hey, we have to disclose this or else I'm holding out.
Exactly right. Affirmative informed consent from Basil, right? And Model Rule 1.4 says you have to disclose to, if you're going to represent this corporation, you have to disclose this information you received to its other members, the 2/3 of the members. You can't disclose that without getting permission from Basil. So you actually basically have to say, Basil, I want your permission to share this confidential information with the other 2 members. That's the only way out of this, aside from simply withdrawing. Yes?
If he says no, is it like a first in time rule that you keep Basil and the corporation goes to somebody else, or do you, like, which one do you keep?
At this point, you would, if Basil says no, you cannot represent that corporation. You have to withdraw from the representation because you can no longer represent that corporation effectively, knowing what you know. Yes?
And so you can't disclose anything to the other members?
No, you'll have to, if he does not give you consent, the confidentiality persists. Persists, yeah. By the way, this is a good reason not to do someone's divorce and then help them form a company, right? Because you get into these sticky situations. So the likely outcome, you have to withdraw. You cannot disclose why. You simply have to withdraw without saying why. Sybil and Gowan will probably be kind of flummoxed, right? But you have to tell them to look for another lawyer, and the lawyer can hopefully explain to them what is happening. That, this is the sort of, he might surmise this is the general reason for a withdrawal in this kind of case. Sticky situation. All right. It doesn't get better for a little while here. Let's take a look at hypo C. So how is this distinguishable? How is this different than the information you got from Basil?
It has nothing to do with the prior engagement.
Nothing to do with the prior engagement. So is there a duty of confidentiality that you owe to Gowan? No, it doesn't apply. You haven't represented Gowan. So what do you think you have to do now? Yes. You've just learned information that could be harmful to your client. Do you have a duty to do anything with that information?
You do, because technically Gowan is not your client, the situation is your client, so you would have to tell Gowan that this is not information that you can hold in confidence, you have to tell the other members.
That's exactly right. You have to tell this information. So you say to Gowan, no, I won't hold that in confidence. You have an obligation not to hold it in confidence. He's not your client. The situation and the soon-to-be corporation is, you've just received information harmful to your client. You have to act on that. You can tell Gowan you are not his lawyer. You should have told him that already. You should have told him that in your engagement letter. You should have told all of them that you're not any of their lawyers. Model Rule 1.13 specifies that in dealing with an organization's directors, officers, members, shareholders, or other constituents, a lawyer should explain the identity of the client. So hopefully you have done that. And now you will have to spill the beans on our friend Gowan here. It's the only thing you're permitted to do. Even though Gowan will now probably try to get you fired, them's the breaks. Better not to have received this information. You assumed obligations for the situation when you took that engagement. You've received information that is in contradiction to the best interest of that situation. You now have a duty to deal with that information. All right, you've told. Now what? Take a look at 7.1D and see what happens when you now hear from Sybil. Really great group of guys and girls, right? This is like... So what do you think? What do you have to do here? This one's a little easier, I think. So, did you keep it in I really hope you don't tell. Oh, sure. I'm totally going to keep that a secret. No, right? Obviously here you have a duty, same duty as before, to disclose this information. Actually, the duty here is even stronger. You are now potentially aware that Sybil has committed a crime. You are an officer of the court. You have an obligation to do something about this. So now you have an obligation to tell Basil and Gowan for sure, and if they don't do anything about it, you may have to reveal this to regulators. You may have to actually go outside of the corporation and inform state regulators about this fraud. So that's Rule 1.13c for those of you who are tracking this, but that's a hard pill to swallow. Now you're really going to make some enemies, but you have to tell the other two, Basil and Gowan, and if they don't act, you may have an obligation. It's sort of a whistleblower kind of concept. So you have an obligation not just to the situation, but at this level, you're an officer of the court, you're aware of a crime, additional obligations apply to a lawyer. Okay, let's turn it one more here. So this is a more of an issue about firms and about how firms manage conflicts. A large firm especially could certainly end up having competing interests. You don't have control. If there are 300 partners at your major, massive law firm, you don't know what they're all getting into. Hopefully you've run a conflicts check, but things emerge. So what do you do with this here? Yeah.
If you're gonna take it, you can do a Chinese wall.
Right. I don't like that term because I like the term ethical wall, but I think the industry has gotten away from the Chinese wall notion. It just has a little implicit bias maybe, but let's use ethical wall, which I think is actually even more indicative. But your firm can set up an ethical wall between your representation and that representation. That's what you would have to do in this case. Now you're aware of a potential conflict, and they're going to represent Patty, and you're going to represent Gowan and Co., and there will be an ethical wall separating you here. So fortunately in a firm, you should have that capability.
You still have to get the waiver though, right?
Whether or not you have to get the waiver, no, I don't think so. Because you simply can. You are being asked to represent Patty. She's not a current client, and she will not become your client. So you simply wall yourself off from Patty and continue representing Gowan.
Do you think that's office-based? Or
Well, this at this level, you should definitely be talking to the general counsel of your firm about like firm policies. I mean, conflicts are, we're spending like a third of a class period on all the rules of ethics here. So in fairness, this is a little bit deeper. But you pointed out the right concept. The concept here is to solve this with an ethical wall, and whether or not that's permissible to the firm would have to do with a much higher level decision among the partners and general counsel for the firm. Yeah.
How does said ethical wall work?
So effectively, you're blocked from receiving communications about this client. You can't. So, like, if you have a large firm, there's probably some kind of information management system where all the filings go and what have you. So, people who are representing Patty are going to be putting their information on the firm system, and barring anything else, you have access to all that information. So the firm will have an IT manager who's going to block your access to all those files and let the attorneys know not to speak to you about the case. So everyone goes out for lunch and say, oh yeah, Patty, blah, blah, blah. Say, no, you can't talk to me about Patty. I represent Gowan and Co., and we have an ethical wall. So you have to enforce that as well as kind of an information technology aspect to it. So definitely get the firm involved at a fairly high level to do that. They have to put those policies in place. All right, so you found a way to resolve all of this, and then you get this wonderful opportunity to sit on their board because these three people think you are just the bee's knees. You're able to sort out all these problems. Can you sit on their board? Can a lawyer sit on a client's board? Yes.
I think so.
Yes, you can. Creates its own set of issues. It's good business for one thing. I mean, that's nice. You get in there, you certainly... In fact, Fenwick had a policy that they would attend all board meetings as a secretary for free, at no charge. It's a way of really fostering that relationship, getting to know other directors, getting to know other business. Lawyers are not prohibited from sitting on the boards. It used to be a common practice. But we won't have time to get into all the details. It is permissible, so that's what you really need to know. It's permissible. You can sit on the board, but it creates a couple conflicts as well. because now the corporation, now you have to put on your business hat and your lawyer hat, and sometimes those hats are at odds. So a deeper issue, it has become somewhat disfavored. It is permissible, but there can be areas where a business judgment would take you one direction, a legal judgment would take you in another direction, and now if you have the obligation of being the lawyer and the director, you're again pulled in two different ways. I would say this is not for the faint of heart. I would not, for your first incorporation, when you're wet behind the ears, so to speak, you passed the bar 3 weeks ago and your first client comes in the door, probably wouldn't sit on their board. It's not a great time to be dealing with that kind of stuff, right? This is a more advanced move, might say, and some attorneys just won't do it. And that might be your practice. Everyone has to find their own ethical standard. It isn't necessarily the minimum required by law, and if you don't want to get into conflicts, you might turn this down. If you're being paid for it, that's kind of an issue too, right? So there are other issues that come up. I talk about them more in my venture class regarding, can you take stock from the company instead of payment, this, that, the other. There are lots of ways you can get into conflicts, but I hope this gave you a general idea about how it can be challenging to represent a number of people and a situation as opposed to just having a client. All right, third thing for today is a doctrine. And this is actually probably the easiest thing we'll do today. It's not a ton of information. It's a relatively straightforward doctrine. We have time to kind of go through it. As I mentioned, defective incorporation is something that doesn't happen very much in practice. It's relatively easy to file, and it's easy to confirm that you filed properly. But there are some situations where a person thinks they have a corporation and they don't, or both people realize there's no corporation, and we'll go through those scenarios, and this can result in liability. So it's kind of a sneak preview to the piercing the corporate veil, because it's one of the first areas where limited liability doesn't work. That you can't achieve limited liability because something has gone wrong. And so whether or not the corporation is going to provide that liability shield, or whether the promoter, the person who has been shilling for the company and what have you, and acting as if it existed, is going to be liable, is going to come up. Okay. So what is this concept of corporate limited liability? What does that mean? Yeah.
If you're an injured party and you're suing, you can only take from, the funds of the entity itself. You can't go after the natural person.
You can't go after the shareholders in particular. So the concept of limited liability, as you correctly stated, is that the owners of that company are not liable for its debts and its torts to the extent that, more to the extent that they've invested in it. That if the company's treasury is empty, they can't go and collect additional monies from your house and can't, foreclose on your mortgage and take away your IRA, for the most part. But there are situations where a corporate promoter can be liable, and then next semester we'll talk about when a shareholder can also be liable. So fundamentally, the question then is, who is a corporate promoter? How do we use that term? Because we also, by the way, this doctrine is also called the doctrine of promoter liability. So defective incorporation and the doctrine of promoter liability are the same concept, so we need to understand who is a promoter. Different than the incorporator. The incorporator actually accomplished something. So a promoter is a person who does preliminary work incidental to the formation of a company. This can include things like soliciting money from investors or encouraging people to enter into contracts with the firm that will exist and doesn't exist yet. Promoters owe a duty of good faith, really a kind of extra good faith, to potential investors. They have to disclose material facts to them and not mislead them. And promoters can become liable for their actions that they did during formation. So limited liability only arises upon formal incorporation, and there are some situations where promoters might lack this limited liability for their actions they took before the company was created. So we're going to take a look at 3 different scenarios where this can come out, and then talk about 2 different theories, one of which Pennsylvania seems to apply, one of which they have flirted with a little bit, before we wrap. All right. There are 3 scenarios we'll talk about. These are like your kind of common fact patterns. So if you see a fact pattern like this, this is you issue spotting for promoter liability. I want to mention one other thing about issue spotting and the bar exam. Corporations on the Pennsylvania bar is almost never tested in isolation. It is almost always tested in conjunction with some other subject. And so you may or may not recognize you're dealing with a corporate issue right off the bat. So doctrines like this can come up in the context of property questions or contracts questions, and the way that the bar is set up, you have usually four paragraphs and usually 4 bullet points that you're supposed to answer on. And frequently, 2 or 3 of those will be on contracts or property or torts, and then one of them will relate to corporate issues in particular. So a combination could be there's a contract, is it enforceable, and the fact is that someone is behind a liability shield. And so you say, so piercing can come in on a contract claim. You deal with the contract claim, there's bullets 1, 2, and 3 on the bar exam. Bullet point number 4 could be the piercing question, or in this case, could be a defective incorporation question. They're a little sneaky, and so I'd advise you to look at Pennsylvania law questions because they really sneak the corporation questions in there, and that's why I'm spending time on this doctrine. Hopefully, you will all now catch that issue and get those points. The 3 fact patterns that you need to know about. Both parties know there's no corporation. Right? They know there isn't formed yet. I say to you, I'm going to form a company, and we agree to have a contract with the to-be-formed company, both of us knowing it's not formed yet. You know I haven't filed the paperwork. There's no pretense about it. We know there's no corporation. What happens then? Second scenario. Both parties believe there's a corporation and there's not, usually because of an error with the filing. You send it into Delaware, or worse yet, you send it into Pennsylvania, and it got stuck at the office and never got it back, and it wasn't stamped, it wasn't signed. These things happen. Happens less in Delaware because, again, you go on the internet. If you're trying to form a corporation in Delaware, you can go on their website pretty easy. Some states don't have such great websites. Maybe you didn't check. And the third is that if you fail to pay those taxes that I mentioned, if you fail to file that annual report that I mentioned, the company can be administratively dissolved and later reformed. And so there's a question of what happens during that period, because if you go ahead and you pay your back taxes with penalties and interest, you can get that corporation reformed. Okay. Let's take a look at that first scenario first. The scenario here, I'm going to present you a fact pattern where both parties know there's no corporation. And the question is, these are common law concepts. These are not statutory. So this comes from a state common law. Under common law, what are the consequences for the promoter if under this fact pattern the corporation was not formed? And this first fact pattern is going to deal with both parties knowing it's not formed. So what is going on in this fact pattern? We have 2 people. They both know a corporation has not been formed. Yet they want to enter into a contract binding the corporation. And in the contract, they have added a provision which attempts to eliminate liability for the promoter. The question is that contract provision going to be enforceable? Is it effective? Or does our buddy Granziano still have liability under the doctrine of promoter liability? Both parties know there's no corporation. The promoter attempts to avoid liability by having this paragraph here. Will it be effective? Yeah.
Is it saying that, upon condition, it's not saying that these are excused if it doesn't happen, it's just saying that once it happens, then he's dismissed of liability, but if it never actually does happen, if he never gets incorporated, then he'll still be on the hook for it?
Good. Read the language closely. And what does it say here? It says that it's their intention, and if they haven't actually incorporated, is he off the hook? No. Right? So 1, if it never gets incorporated, clearly the provision doesn't even kick into effect. So that's the first problem. First problem is that we don't incorporate, the provision on its own language doesn't protect him. Now, if they do incorporate, is this provision going to protect him retroactively? And the answer is still no. Still no. Right? They had that intention and this novation, but according to the courts, Granziano will remain liable as a promoter. He's not able to avoid that promoter liability through this provision here. There must be a novation. There must be a new contract where the corporation, after it's formed, steps into the shoes of Granziano. Currently, this is a contract between Granziano and RKO, even though it says otherwise. In order for him to be off the hook, RKO has to let him off the hook by having a new contract with a new party, and that is called a novation. So, questions on that first point? Yeah.
Can you explain that differently? I don't understand why he's off the hook. Because it says, upon condition that such incorporation be completed by closing. So
Mhm.
if that condition isn't met, then wouldn't that just void everything that precedes it?
So, Tyler's point, if the formation doesn't happen, clearly this provision doesn't do anything.
Just that provision.
Just that provision doesn't do anything, and so he's definitely still on the hook. I'm saying that he's on the hook no matter what, but he's definitely on the hook if there's no formation, because this provision does not apply. The idea is here that the contract is saying that upon formation of the company, there will sort of be an automatic novation where the company is going to trade places with Granziano and relieve him of contractual liability. That's not effective under law, even if the corporation forms. Even if the corporation forms, Granziano still has to get off the hook by RKO and Kent Enterprises entering into a new contract, which expressly says that they're going to tear up the old agreement, and there is the RKO and Kent Enterprises have to agree to this new agreement, and part of that agreement has to say the agreement between RKO and Granziano is null and void. And that contract, that new contract, if supported by valuable consideration, is called a novation. And you actually have to go through that additional process of having a novation after the company has incorporated. You can't just have this language in the contract and get away with it. Yes?
What if Graziano already owned it for a time, for the incorporation to go back, or does the corporation have to actually make a contract with Graziano for him to transfer his interest in the corporation?
I'm not sure I follow that part of it.
If he went through with the deal with RKO as an
Mhm.
individual, and he owned the rights or whatever he owned, and then he wanted to transfer it to the new corporation after it was formed.
Oh, so that's not this fact. So to be clear,
It's
like,
not in the- yeah,
you're saying if Granziano and RKO entered into a contract and he bought property, yeah, Granziano would have to give that property to the company as a subsequent matter. Yeah. This is also true of intellectual property, and so we'll see that more with formation aspects. But yes, a person you have to actually contribute your property to a company. So if he actually got the property and owned it in his name and in his title, he would have to give it to Kent Enterprises. But this is not that fact pattern. This fact pattern is saying that the exchange never happened, and now RKO wants to sue somebody about it. Right? They didn't actually get the sale done, and who can we sue? Can we sue Granziano? Yes. Granziano is liable on the basis of promoter liability. So now let's add one more dimension to this here. After the incorporation, so there is an incorporation, Tyler, so we've resolved that issue. After the incorporation, Kent Enterprises has this organizational resolution or board minutes, this resolution, which says that the corporation is going to take over the obligation from Granziano. Is this enough? Yes.
No, because you would still have to have RKO agree to that.
Exactly, right? Again, we need a novation. We need a new contract with new parties. This board resolution is not enough. This does not do the trick. There's no indication that RKO has signed on to getting Granziano off the hook. Granziano's off the hook, and he can't unilaterally get himself off. He can't transfer that liability to Kent Enterprises. It requires a novation, a new contract, which is going to, for good and valuable consideration, allow Granzion off the hook, because that new contract with RKO as a signatory is going to let Ken Enterprises stand in his shoes. Tyler.
So they still need innovation, even if, like, RK lays out, like, once this happens, like, we weigh any possibility of coming after Graziano.
Yes. So that's exactly what this is saying. Even though the contract said in the future there will be a novation, right? We still actually need to have a signed novation with that new entity. At this point, the entity can't accept the liability, and it's not enough that the board minutes happen later. So if both parties, basically, upshot for this fact pattern, if both parties know there's not a corporation, the promoter is basically always liable. If both parties know there is no corporation, the promoter is essentially always personally liable. The only way he can get off the hook is after the incorporation. For every obligation that he is on the hook for, there is a novation, a new contract that for good and valuable consideration allows the new corporation to step into his shoes and expressly lets him off the hook, signed by the party who would hold it against him. So that one's a simpler one. All right, the next fact pattern that comes up is when both people are mistaken. And now we have some fairness doctrines, and now we actually learn a little doctrine law, a couple of equitable doctrines that come up under common law. If both people mistakenly believe that a corporation exists, courts have taken a few different approaches. So as a matter of strict law, since the corporation was never formed, there is liability for the promoter. So the question then is, as a matter of equity, are courts going to actually enforce that against him or not? Courts are somewhat split, and different courts extend different measures of leniency. What you need to do for this is, if you do see a fact pattern like this where there is a mistake about a corporation being formed, is to advance two theories. Two theories that we're going to cover in a minute. The first is going to be based on well, I'll get to the theories in the slide on the theories. We have two that we're going to apply, and we're going to try to advance both, and I'll go through the factors. Here's the hypo, though. Really, you're going to see, this is it's a very bare bones fact pattern. It's meant to be almost a template for the type of fact pattern you'll see about this. You have a corporation, you have a quote-unquote corporation, right, that enters into a contract. It actually doesn't exist, and both parties were mistaken. And now, are we going to hold Bob liable? So we are going to apply two separate theories about this. One is whether or not we're going to so the first is to prevent Equipment Co. from suing Bob on the doctrine of corporation by estoppel. So we're going to stop Equipment Inc. by applying the doctrine of corporation by estoppel. So he is estopped from the lawsuit because of the mistake. Or some jurisdictions will say a de facto corporation exists. And so our second doctrine is the doctrine of de facto corporation. So let's take a look at the difference. I'll start with a de facto corporation. It has three elements. Under the doctrine of a de facto corporation, if there has been one, a good faith attempt to incorporate. A good faith attempt to incorporate. So you filed it right, it just didn't get marked, signed, sealed, whatever, for whatever reason. Two, the promoter was unaware the corporation had not happened. Right? You can't have actual knowledge that the filing bounced. The promoter was unaware the incorporation had not happened. And third, the promoter used the corporation as a form to enter into a contract with a third party. So here we're sort of saying, okay, you made a good faith effort, the filing bounced, you had no reason to be aware, it's not your fault, we're not going to hold you liable for the contract you entered into. We're going to treat the corporation as if it existed, even though it didn't. So that's one leniency courts will provide to allow people off the hook in the case of a mistake. And that's called the doctrine of de facto corporation. It has three elements: good faith attempt to incorporate, promoter was unaware that it didn't happen, and they use the corporate form to contract with a third party. The other doctrine is called the doctrine of corporation by estoppel. And this is an equitable doctrine that prevents the party from suing the promoter when there was no attempt to incorporate or a bad attempt to incorporate, so it doesn't have that element, but the third party assumed they were dealing with the corporation. So if you thought you were dealing with a corporation, you didn't think Bob was going to be liable, so it's not fair to hold him liable. It would be a windfall. You thought that you were only going to have recourse against Newco, not against Bob. You thought you were dealing with a corporation with limited liability. As a result, you are estopped, prevented from arguing that you are for suing Bob in that case as an issue of sort of fairness because you did not expect to have that protection. I'm out of time, so I will conclude this next week. We only have a couple slides to go through, but I want to talk about defective incorporation. If you don't mind, can I take like 3 minutes to just preview it, just so you have a little bit of a sense of it? Okay. So, defective incorporation on the third instance reinstatement. We talked about reasons it can be administratively dissolved. When the corporation doesn't exist, the promoter has liability. This one's really simple. You pay your taxes, the corporation gets reinstated, and that applies retroactively. So this one's actually pretty simple. I'll give you that hypo actually very briefly. This is the second to last slide. The corporation fails to pay its taxes, it gets dissolved. The corporation enters into a contract with a third party. The promoter is liable, but the corporation pays its taxes. The corporation is reinstated, and that liability protection goes back, is applied retroactively. So, long story short on this one, you can avoid liability by paying the taxes. Why do states do this? It encourages paying your taxes. Right? You can get rid of the liability that you had if you go ahead and pay your back taxes. So this doctrine is actually pretty practical. And so I'll just summarize then, and we'll wrap for this. We'll get into the more interesting stuff. I hope more interesting stuff next week as we see some documents. Incorporation is a relatively simple process. The certificate of incorporation only has to name the corporation, the number of shares, the purpose of the corporation, the registered agent and their office, and the name of the incorporator. The organizational meeting will be where the working structure happens. We'll see that next week. A lawyer can represent a situation or a corporation, but it creates some messy rules of ethics that have to be dealt with. And fundamentally important to make sure that participants are aware of those complications and get informed consent when there's a conflict or withdraw. And defective incorporation can happen in 3 ways. If the parties are aware there's no corporation, the promoter is liable unless they agree otherwise, and you need some kind of novation to get them off the hook. If the parties are not aware, there are 2 doctrines that get him off the hook: the doctrine of de facto corporation and the doctrine of corporation by estoppel. If it's formed and dissolved, you pay your back taxes, you're off the hook. And as we'll learn next semester, if a corporation is formed and misused, we can pierce as well. So this is kind of related to veil piercing. So that's all, folks. Thanks for the extra few minutes, and I will see you next week.